Hi, I'm Attorney Iworski. How are you?
Good, how you doing?
Good. So I'm covering for Attorney DeCroce today. So you're scheduled for a sentencing hearing today on the disorderly conduct, and then you were scheduled for a trial on the breach of bail charge, right? Is that what you have as well? Okay. So what we're going to do today is we're just going to go forward with the sentencing hearing. I'm not going to go forward on the breach of bail. You were convicted on the disorderly conduct. I don't see a reason to pile additional charges onto you. So you'll be sentenced on the disorderly conduct, and then we'll be done today. Okay?
So you're dropping the breach of bail?
I am. Yep. Okay. And I spoke with the trooper about it, and he's fine with that. Okay?
Good. Thank you so much.
All right. Sound good?
Yeah, no problem.
All right.
All set?
Yep.
Read that, Frank.
Yeah, well, I mean, there's no way. I got the law right here, right? So, I didn't create danger, obviously, which is why this has been dropped, and I didn't commit a felony, okay? I'm being persecuted for exercising my First Amendment.
You and I just didn't we just have
because I'm here today for nothing. That's why I'm getting angry.
You're here for a sentencing hearing.
Yeah, I know. And I got found guilty of disorderly conduct for less than what I'm doing right now.
Okay.
For being loud.
Okay.
Because I have a loud voice. So I got found guilty of disorderly conduct for having a disability because I get excited and hyper.
Buckle up, because what you're about to witness is the perfect storm of sovereign citizen logic, courtroom delusion, and a defendant who believes every consequence is a personal attack on his rights. In today's case, we meet Frank, a self-proclaimed First Amendment auditor, cop watcher, and now self-appointed legal expert representing himself in court. And let's just say, the moment he opens his mouth, we know exactly where this is going. This isn't just a sentencing hearing. This is a masterclass in how not to behave in front of a judge. Frank walks in convinced he's being persecuted for exercising his rights, despite the fact he was literally convicted for shouting outside of public officials.
Oh, and I was found guilty, yeah. I had my day in court, and what was I found guilty of? Why am I not under arrest for disorderly conduct right now?
Sir.
Why am I not under... Hey, listen, don't give me no directives. You're just going to make it worse. Ridiculous.
Hey, Frank.
Absolutely ridiculous.
Frank, was the breach of bail when they arrested you here? Was that one, or was it a different one?
Judges on the way.
Yes.
We'll wrap this up and you'll be on your way.
That was the one, thank you. That was the breach of bail for the New Hampshire 9 arrest. For where someone was arrested for saying amen. And I was arrested for, we don't know yet, making a loud noise, which is all on video, and I didn't make one fucking peep. Not one fucking peep.
Yeah, well, we would know if you had.
You're in a courthouse.
I don't care. It's not illegal to swear. Okay?
If you
I don't need,
disturb
listen,
another
have me
people-
arrested. Do something. Do something.
I don't want to.
Do something. Because you can't.
I'm trying to
Don't
work with
give
you.
me directives and tell me what to do or what to say or anything.
Right.
And here's where the spiral begins. Notice how Frank starts with a classic sovereign citizen-esque tactic. Redefine the law to fit whatever narrative he wants. He claims he didn't create danger, so the charge shouldn't count. But legal definitions don't work like personal opinions, especially not in a courtroom. What's fascinating is how quickly his emotional temperature shifts. One moment he's calm, the next he's erupting because he shouldn't be here. That unpredictability is exactly why courts take disorderly conduct seriously. It's not about volume. It's about behavior, escalation, and potential risk.
I'm trying to, but these people, they all want to take their time. Oh, hey. Oh, just calm down. Let it be cool. No, this is absolute bullshit why I'm here today. And everybody knows it, and that's why you dropped those charges.
I told you why.
So I get it. You're cool. You dropped the charges. I appreciate that. It's nothing personal against you. This is business.
I'm being cool.
I am being as cool as I can be. Okay?
Come on, Frank.
You want to get this done?
Oh, I'm ready. Let's do this thing. I've been here. Let's go.
The priest will enter.
All right, honorable court is now in session.
All right, good morning, everyone. Frank Staples, docket number 435, 2021 CR 240, and dockets number 435, 2021 CR 1692. Attorney Iworski does appear on behalf of the Newfields Police Department. She's filling in this morning for Attorney DeCroce. Mr. Staples does appear. He is self-represented. We are scheduled this morning for a sentencing hearing in the 2021 CR 240 on the Class B disorderly, and then additionally the matter is scheduled for trial in the breach of bail charge. Are we ready to proceed?
Judge, we're going to go forward on the sentencing order. As I told Mr. Staples, the state police are here. I had an opportunity to speak with them. Although we are ready for trial, I think in the interest of fairness and equity, he's been convicted of the underlying disorderly conduct charge, so we're going to use prosecutorial discretion.
How is it underlying when the breach of bail took place?
Here we get the crucial context bomb. Frank wasn't convicted for being loud in a general sense. He was convicted for showing up at a government official's home, shouting at them and their family. That's not activism. That's targeted harassment. And courts take that very seriously. Sovereign citizens often blur the lines between freedom of speech and freedom from consequences, but the law draws a very clear boundary. The First Amendment doesn't protect threatening, aggressive, or intrusive behavior, especially at someone's private residence.
The breach of bail charge, and we're just going to go forward on the sentencing hearing with the disorderly conduct.
All right, very good. And then I will give you that one. Oh, wrong one. I gave you that one. This is the breach.
That's somebody different.
All right, thank you. All right, so with that then, if we're ready, we'll proceed with the sentencing and the state's recommendations. Mr. Staples, what I'm going to do is I'm going to hear from the state first, what they're recommending relative to the disorderly conduct, which was a Class B misdemeanor in that matter. And then after I hear from them, I'm certainly going to hear from you as to any recommendations or any position you take as to penalties, okay? So with that, thank you, Attorney Jaworski.
Judge, the city's going to ask for a $1,000 fine, $500 of that to be suspended for 2 years good behavior. Your Honor heard the facts and circumstances of this case. This is an individual who has racked up similar charges to this recently.
That get dropped and dropped.
This moment exposes a pattern we see often in pseudo-legal defendants: selective self-control. Frank claims he has a disability that makes him loud and excitable, yet somehow he manages to remain perfectly calm until authority pushes back on him. That's not a medical condition. That emotional volatility paired with entitlement. The moment he encounters resistance, he flips into aggression, and you'll notice the prosecutor and court staff try repeatedly to de-escalate. But Frank sees every request, every directive, every question as a threat.
Prior conviction for bail jumping in 2013, February 11th of 2013. It looks like he had 1 to 7 years for a sentence with counseling, mental health treatment. He had a possession of prescription drugs also in 2013 where he was convicted. He had multiple counts. He received a 12 months time served sentence in that particular matter. He had a possession of a controlled drug with intent to sell conviction in, looks like 2004 out of Hillsborough.
When is my sentence over? When is the crime done?
Yes, Mr. Staples, please, I'm going to hear from you also.
Yeah.
But she gets to recount what she
Fine.
wants,
She
so
can do whatever she wants.
thank you.
Another possession of controlled drug with a 9-month sentence. Shoplifting conviction in 97.
I was 17! A
Mr.
juvenile!
Mr. Staples,
So she's bringing up my juvenile record?
This section is actually a fascinating glimpse into courtroom dynamics. Many viewers will wonder why the judge tolerates this level of disrespect. And honestly, that's a fair question. In most courts, even a fraction of this behavior would result in an immediate contempt charge. But here, the judge may be choosing efficiency over escalation. Frank has been through the system many times, and the court likely recognizes that confronting him directly would just trigger another hour of shouting. Instead, they're aiming for a controlled landing. Pass the sentence, keep the peace, and move on.
Hey, come on! What's really going on here?
Staples, do I need to take a break? Let's just get through.
Let's get through it then!
Telling me what she wants to recommend and about your.
And why? Because of all these past crimes all the way back to when I was 17?
All right.
Get the fuck out of here.
Stop. And please with the language. Attorney Jaworski.
Judge, he has a robbery conviction in 97 on Hillsborough South with a 12-month suspended sentence. That's the first half of his criminal record. He does have an additional 6 pages, but I won't go through every detail. I am asking for a little bit of an enhanced fine, although I am asking that half of it be suspended for 2 years good behavior. Also, part of that good behavior is that...
Not paying shit. Believe that.
Mr. Staples.
Sure we have the address. They cannot be allowed to respond to that same address with a disorderly conduct occurred, Judge.
Okay, Mr. Staples, you've heard the recommendation of a $1,000 fine with 500 of it suspended. Do you wish to be heard on what you're asking the court to impose within the limits of the maximum amount?
Yeah.
$1,200 fine.
This is one of the most ironic parts of the entire hearing. Frank complains that the prosecutor is mentioning his old charges. Yet those charges demonstrate exactly why the court is recommending an enhanced penalty. A sentencing hearing is specifically designed to review criminal history, not to embarrass, but to assess risk, pattern, and accountability. And here's the kicker. The prosecutor isn't even listing everything. She mentions 6 pages of additional history. She chooses not to read aloud. That's not excessive. That's merciful. Frank interprets it as an attack, but legally, it's standard procedure.
Didn't do anything to cause any sort of pecuniary loss or any damage or anything like that. And I also am asking you to reconsider your finding of guilty, because I will be appealing this. I'll put you on notice, and I do want to know exactly what did I do to commit disorderly conduct, because it was nothing even like what I've been here today in this courtroom. Okay? I didn't do anything that was disorderly. I asked why I was being threatened to be arrested. The man never asked me to leave the area. You've seen the video. He lied in his testimony. So I want to know why I was found guilty to begin with. What? You need to articulate yourself.
You've had your opportunity.
$0. No penalty whatsoever.
Okay, thank you. And I've heard your testimony and listened for several hours at the trial, and I've issued that, and certainly you do have the right to appeal, and I will expect you to do that. So with that, I will adopt the state's recommendation. I will impose a fine of $1,000. $500 of that will be suspended for a period of 2 years for your good behavior.
Put me in jail now then, $50 a day. Let's go. $50 a day in jail because I ain't paying shit.
It's 150 now.
So
150, whatever. We do $10 a day. Let's do it.
don't sell yourself short. Are you able to pay the $500 fine? I'm sorry, yeah, $500.
I ain't paying no $500 fine.
All
You
right.
gotta be kidding me.
So you know there's an additional time payment fee of $25 that gets added.
Don't care. I ain't paying none of it.
This moment shows how deeply disconnected Frank is from the legal reality in front of him. He demands a $0 fine because he did no damage. But disorderly conduct isn't about property damage. It's about public disturbance, safety, and behavior that forces law enforcement to intervene. His insistence that the court justify his conviction during sentencing demonstrates how little he understands the process. The verdict phase is over. The evidence has already been reviewed. This hearing is solely about determining consequences.
If I put you down, that'll be paid in full within 30 days, in addition to...
Say whatever you want to say.
That's what I'll do.
Okay? Ain't gonna happen.
We'll be in recess. Thank you. Good
Yeah.
luck to you, Mr. Staples.
Thank you. Have a bunch of bullshit.
Well, have a bad day.
Huh?
Wish him a bad day.
Okay, yeah.
Amazing. You told her you weren't going to pay, and she's like, well, we'll put you on a time payment.
We'll put you on a time. Put me in jail now!
They don't want to put you in jail.
go, let's go.
Put me in jail now. 5 years of solitary confinement, you get fucking fined, $5 fucking fine, get the fuck out of here.
I love how they brought in the
Unbelievable,
SWAT.
you bring up all that fucking record too. I've changed my life. I have a fucking business where I help people reintegrate from prison and from rehab and from homelessness. And you want, when are my past crimes done with? When do I live it down?
You already know the answer to that, Frank.
Never,
Never.
right?
Let's go, come on.
We feel it's right around. Bunch of bullshit. Hope you feel real good about yourself.
I don't think I've ever heard of anybody paying fines any activists. It's funny, they think they get us and they don't.
Let's do it. I love this game. We could play this all goddamn day.
They just want to bring him back in for another hearing.
Yeah.
That's what they want.
Yeah.
And that brings this chaotic courtroom saga to a close. What we witness today is a prime example of how self-representation, combined with defiance and sovereign citizen ideology, almost always ends in disaster. Frank entered this hearing convinced he was a victim of persecution, but the record, testimony, and his own behavior tell a very different story. The judge exercised extraordinary patience. The prosecutor laid out a clear history of repeated offenses, and the sentence, a fine with half suspended, was arguably lenient given Frank's conduct both past and present. Instead of taking the opportunity to demonstrate responsibility or remorse, he doubled down, escalated, and ultimately left the courtroom furious, fine in place, and still refusing to accept any accountability.